Both New York teams lost.
Mookie Betts sends a high fly ball to deep left field. Nimmo's going back at the wall. It's gone.
Betts helped power the Dodgers in a 10-2 win over the Mets on FS1. Los Angeles leads New York in that series 3-1. In Cleveland last night, the Guardians had a walk-off home run in the 10th inning to beat the Yankees 7-5, but New York still leads that series 2-1. I'm Dave Anthony. This is Fox News.
Serving Lawrence County on AM 1370, 105.3 Lawrenceburg, and Loretto on 95.3. This is The Legend, WDXE.
That's us, WDXE, and it's time for Stan Pierchoski with Pierchoski Estate Law. How are you, buddy?
Good morning, Jeff. I am doing good.
Yeah, I missed you last week, but the show carried on.
It did. It did. And here we are again.
Yeah. Well, good to see you. You and I were talking off the air there. You went to early vote yesterday.
I did.
Yeah.
I did. We, for me, it's just across the square there in Pulaski. And we walked down, the three of us walked down and got it done. And, I think we went there about 2-ish. No, it was right after 1. It was right after 1.
Yeah.
And we were in, we were out.
Yeah.
I mean, there's people coming and going, but there was no line of any kind.
No line. Yes.
Went in and, you do your register. Actually, when I went in, you have to show your card and your license, right?
Right.
When I pulled my voter card out, it's in my wallet, and it's not laminated. And I pulled it out, and it's like, gosh, this thing's been rubbed so much, it's hard to read it. When she saw it, she said the same thing. She said, let me print you a new one, because it
got a new voter card. Okay.
This looks pretty rough. You fill out the paper, you go in, you vote. The ballot wasn't too long. It was like 3 or 4 pages, and with one choice on each page.
Does Giles County have some local elections going on too?
No, not that I saw.
Giles County or the city?
No, nothing in, like you mean the sheriff and stuff.
Yeah,
no.
anything like that.
No, that's on an off year, I think.
Okay.
That would have been the 2022 cycle, so that's going to be again in 2026.
Yeah.
So, yeah.
Yeah.
But no, there was not. There was just the president. There was some congressmen. There were some senators.
Okay.
And there was there's one local issue, like a tax issue thing.
Oh, okay.
Yeah. But other than that.
Okay. Interesting.
Kind of like vote for or against referendum, I guess it was.
A referendum.
Yeah.
Now, that's a legal term, isn't it? Or used as a legal term?
It is, and I don't ask. I know a referendum is an action.
Yeah.
But that's about it.
Okay. All right.
I'd have to hurry up and Google it.
Wow.
We could all do that.
Well, has life been busy for you lately?
It has. Maybe a little too busy. A lot goes on at the office on a daily basis anyway.
Yeah.
And I'm involved in the Grease show at the.
Yeah, that's right.
Which is opening night is 3 weeks from tonight.
Oh,
We had a rehearsal last night, and I'm thinking to myself, oh man, may have to squeeze a few extra rehearsals in there.
Oh, okay.
Because it's a musical, we spend a lot of time doing choreography and the vocals, and now we're just getting to the actual presence on stage and the acting and the colloquy back and forth. And I mean, it's a little rough right now, but it's always like this. Into the last week, you get worried, but it just all seems to come together. So
well, part of that though is what makes it fun.
Oh yeah.
Even if there's a mess up during the show, it kind of makes it fun.
Well, we train for that. How to improv or something like that, because it happens. You can't just stop.
Right.
You got to keep going. So there's certain things we talk about to make that better. But I do got to tell you this. I think it was last week when a lot of times when I'm done with the show here, if I've got some Lawrence County deeds to record, I will. Instead of sending one of my staff over here, I'll just run over the registry of deeds after the show here.
Yeah.
Go in and record them.
Yeah.
And I did so last Friday when I was here. And the gals in there, I know them, and we talk and shoot the breeze for a few minutes whenever I'm over there.
Sure.
And I was telling them about the Grease show. Okay.
Yeah.
And I've been calling it Grease with a twist because all the cast members are like 40 and above. Now we do have a few younger folks in the ensemble and some of the, the background people, but the leads are all. Like 40 and up.
Right.
And I was telling them about that. And the one gal, Miss Tara, she goes, oh, Golden Grease.
Golden Grease. That's perfect.
I'm thinking maybe I ought to change the name of this play to Golden Grease.
That's good.
Yeah, that was funny. So
That's good. Golden Grease. That fits. That fits.
A little insulting, but funny.
Yeah, that's
it
perfect.
Does fit, yeah.
Well, they had the Golden Girls show
right,
that was forever a big popular show.
And now they got the thing called the Golden Bachelorette where she's in her 40s.
Yeah,
or 50s.
I haven't watched that, but I've seen advertisements.
I just saw some of the advertisements go by.
Yeah.
It's like, yeah. So anyway, talk about some more.
Keeping ourselves entertained.
Yeah, talk about some more exciting things like some estate planning, right?
That's right. And that is exciting.
It can be. It can be. You know, we had a good week. We had an approval come through just yesterday. Actually,
Okay.
it was like almost close to 5 o'clock. I know I was like, we had a rehearsal last night, and I was kind of winding down what I was doing at the office and getting ready, and I just saw an email pop up, and there it was. You know, and it was, I didn't see the paperwork yet, but it got so we got an approval for one. It wasn't really a difficult one. There was some issues with it. We had some trouble with the exam and stuff, but it ended up just the way we wanted it, where it reached back to the application day and everything. So that was good news. I haven't even got a chance to tell the family about it yet because, like I said, it was late in the afternoon yesterday.
Awesome.
So that was good. I've been writing a lot of trusts lately. We had a seminar at the American Legion in Pulaski, like September the 14th or something like that. That was the last one we had.
Yeah.
And we got a lot of engagement from that. And I've had a lot of meetings with people that came to that because we had a pretty full house for that. And so we have a lot of trust plans on the schedule. But we're we got this next seminar coming up. It's going to be, well, it's about 3 weeks out.
Okay.
No, less than that. 2 weeks out. It's November the 2nd.
Oh, right.
So that'd be 2 weeks from tomorrow.
That is pretty close.
Now that's the one that we're doing up in Franklin. Okay. And it's about a 45-minute drive, maybe not quite, to get there because it's not all the way in Franklin. It's kind of in I guess you could call it an industrial area of the thing, where they got a lot of places. There's a place where they have a lot of rental space for offices. Some of the stuff looks like it when I go up there and walk around. Some of the spaces they have look like recording spaces. They got a lot of looks like audio equipment, but they have a nice little meeting area. The name of the place is called Suite 501.
Yeah.
And its physical address is 416 Mary Lindsay Polk Drive up in Franklin. And so we're going to do that seminar November the 2nd, which is Saturday. And we call the seminar Wills, Trust, and the Nursing Home. And that's what we talk about, wills, trust, and nursing home. We always start those at 10 o'clock in the morning on Saturdays. And the presentation lasts about an hour to an hour and 15 minutes. I just seem to have a hard time jamming it all in an hour, but a little more than an hour. Then we have a question and answer session, Q&A, that I ask people to just save it to the end, and people really take advantage of that. And they ask a lot of questions, a lot of good questions, and so we're usually there for about a good another 45 minutes just answering questions. Now, you don't have to stay for the questions, but a lot of people do.
Right.
Because, the questions are common to people. When somebody has a question, many others are thinking the same thing. And so we answer those questions, and then we get out of there, I don't know, whenever, about noonish or a little after. But it's a nice little venue up there. So if you wanted to make the drive to come up there, I don't think the next one's going to be till sometime in January. And if you do it in January, it's probably going to be more mid to late January, because of the holidays and all.
Right.
Excuse me. I was telling you I feel a little sniffly this morning, so
Yeah, you got a little bit of it.
doggone
Right?
cold weather. I hate to complain about it, but
Yeah.
because we've been complaining about the heat so much, and now it's nice and cool. But anyway, if you want to come to that seminar, it's a nice little drive.
Yes.
On a Saturday. Call my office and get on the RSVP list. Okay. I'll give you the number now. I'll give it again at the end of the hour, but 931-363-7222 for Pierchoski Estate Law, Pierchoski Elder Law. Talk to Alex or talk to Tammy or talk to Miss Courtney, and they will get you on the RSVP list, and then you can come on up to that. If you can't get on the RSVP list and you make your decision to come at the last minute, we always allow for walk-ins, and they're always welcome. Just like to have a head count. So, but if you hadn't been to one of my seminars, you ought to give it some thought, because I get a lot of very excellent reviews on my seminars about the information being very useful, very informative. We talk about things you probably never heard of, or when you hear it, it's like you're really thankful to hear that there are such options and things to do.
Absolutely.
And it kind of works like that. So if you, if you come and learn something and decide it's just not for you, then that's just not for you. But you'll still learn something, and you will have made that informed decision, and you'll feel more comfortable with that decision.
Absolutely.
Sometimes you make a decision, you're just winging it. It's like, I don't know if that was, you decide to do something. I don't know if that was a good thing or a bad thing, but I did it. If you get a little more information, you make a decision, then you're a little more comfortable with it. Whether it's yay or nay, you're more comfortable with your decision because it's informed.
Right.
I don't know how you can make a decision about anything. We've all done it without the information you need, but we've all done it on things.
Well,
like,
you're just guessing if you don't have
it's
information.
kind of like fixing your car.
Yeah.
I've got one I got to fix now. Something happened to it yesterday, but I'm saying, you don't know what it is, so you like say, well, I'm just going to buy this part and replace it to see if that does it.
Yeah.
You don't have the information you need. You don't have the tool that hooks up that talks to your computer and tells you close to exactly what's wrong. So it's always good to get the information. And, the people that come to these seminars are just thirsty for it. I mean, I talk to a lot of them, and they're looking, they're trying to find answers. They're on the internet, they're talking to other people, and they're getting a real hodgepodge of stuff.
Sure.
And they're saying the more I look into this, the more confused I get. And that's not uncommon for certain topics, especially on the internet. The internet, used to be way back. The old adage was, if it was in print, it has to be true.
Yeah.
Like if it was in a newspaper and a
Right.
magazine, then it had to be true, which of course is not a criteria, but that was the adage that
Sure.
people would feel like. And I hope people don't feel like just because it's on the internet it's true, because I'm going to tell you what, everybody and their brother has an opinion, and everybody and their brother puts it on the internet.
Yes,
and,
they do.
and nothing makes it truthful. Now, I'm not saying it couldn't be true or correct. I'm saying it doesn't. They just put it up there. There's no fact checking. There's no vetting of what's put on there at all. And
Right.
so now, which is a shame for the people that do post good stuff. You can't find it in the weeds, because
That's right.
that sort of thing. So I don't blame them for being confused. I don't blame them for struggling to find things and just not knowing what to do. Now, when they come to hear me, I mean, I try to be the voice of authority. When I talk about things and give my opinion, it's I'm pretty much bound by my opinion. So I like to think what I give people is the straight scoop. And I usually back it up with where it's coming from. The statute or the rules or
Sure.
stuff like that.
Sure.
And it needs to be. And the rules are complex, but you can distill them down to basic concepts, and then people get a good feel for that.
Sure.
So anyway, and it's usually I kind of like the seminars, especially like the question and answer period. That's probably my favorite. It kind of lets me know where the people what they're thinking,
Yeah.
where the rubber hits the road, the experiences they're having.
Yeah.
And then that helps me when I talk about stuff, because I know the kind of stuff people are going to run into.
Sure. Speaking of that, the lines are open, 766-9393. We can take questions here for Stan if you want to get in on the program. We'll do that.
Last week I think Charlotte filled in for you.
Yes.
And I think we went the whole hour, and I remember saying at the end after we signed off, I said, I think we forgot to give the phone number.
Well, we can do it now. 766-9393, of course, for our local listeners. It's a 931 number if you're listening, online or somewhere else. 931-766-9393 will get you through to us. You can talk with Stan if you got questions or
Just want to relate
some
an experience.
circumstance or relate an experience. We're happy to hear it and talk with you about it.
And I keep forgetting we are some online. I can't quite see the computers very well, but
We are.
And you might want to tell people how that works. Too.
Well, you can find us on Facebook at WDXE. Just Facebook WDXE. You can find it there. That's the easiest way to get it if you're a Facebooker. And, of course, you can listen to us online at WDXE.com. You can just listen live, this live stream. WDXE.com is easy to do as well.
That helps because, a radio station only reaches so far.
That's right. We have people that listen out of state a lot.
Yeah.
We really, really do.
And one thing I got to commend the management here for this, this concept, they call it visual radio, which is a pretty cool concept. It's creative.
We like it. Well, we got a caller, and no telling what we may hear.
There you go.
Good morning. How are you?
I just typed him an email, so I may send it, but I lost track of time. He may have covered this, but years ago, my son was in a wreck as a college student in another state, another driver, and so I just, he tried to assure me that it was fine, don't worry about it, but our health insurance had to have 30 days notice in case, let's say they didn't cover his, let's say he had to go to the emergency room, say the emergency room billed you. So I went up there and got a POA because nobody would even talk to me. Now, he was like just 20 years old, and I wondered if that was true like in Tennessee. It would seem more important today. I'm trying to share some of these things with my son and the grandkids now, going back. If he would discuss something like that about, it seems to me like you would need one at a younger age with a lot of things going on, because I ran into issues at the age of 16 with a doctor's office is not wanting to deal with the mother, and this is 20-something years ago.
Yeah. Okay. Well, we'll talk about it. Okay.
Okay, thank you.
All right, if I understand her, I think maybe she's talking about, the necessity of having someone with a power of attorney for you, even at a young age.
That's what it sounded like to me. And, I have often said people need power of attorney at any age.
Yeah.
I mean, that is a very, very important document. And it has a lot of ramifications if something happens and you don't have it. So let's talk about it a little bit.
Yeah.
First of all, let's talk about what a power of attorney is.
Yeah.
Power of attorney, it's an old common law form of action. And basically, you can empower somebody to make your decisions for you. Now, power of attorney can be general, and a lot of people have what is called the general durable, which is like all sweeping.
Yeah.
Or it can be a very specific power of attorney. Okay,
Yeah.
like sometimes as an attorney, some people they're out of state or something, and I'll be power of attorney for them for strictly for the sale of a specific piece of real estate.
Yeah.
I can make decisions on that. And that's an example. But it can be for very specific purposes. But the general durable power of attorney, I think everybody needs one because here's the problem. If something happens to you, you want a loved one, a trusted person, a trusted loved person that will make decisions for you.
Right.
Then if you have a trusted trusted family member, they're going to make the decisions you would make if you could make them, right? Which is what a power of attorney is. It allows another person to stand in your shoes and do what you would do if you could do it.
Yes.
Okay? Now, it doesn't always have to be incapacity, but let's just limit it to that. Because if you're not incapacitated, you're probably making your own decisions. But, it could be something like you go away for 6 months on a European vacation, you have somebody just take care of business for you.
Right.
There's no incapacity there, but you could do that. But the real advantage is if there's an incapacity. So you put that together now during life. I mean, while you're of sound mind. You put together a document, you sign it, you give someone that authority. And we typically name a couple of people in a consecutive order because you don't want to run out. And if something happens to you, now that thing springs to life, and that person is now making these decisions for you. And it's a real lifesaver because if you don't have it, I think that's where she was going.
Yes.
Now, I'm not going to talk about being a minor just yet. We'll come back to that. But if you're of majority, age 18 or more here in Tennessee, and you need to make a decision for someone, even if you're that person's parent.
Yeah.
Okay, because being a parent means something, but not once you turn 18.
Right.
As far as what I'm talking about.
Right.
They won't talk to you.
Not from a legal point of view.
Well,
no.
they won't talk to you. I mean, it's not they won't talk to you. They won't do anything. They can't act.
Right.
And it's like, but I'm the mom. I'm the dad. And they're saying, I know, but you haven't got the legal authority to make decisions for this adult person.
Right.
You haven't got it. Now, if you have a power of attorney, you do. Now, when you're young, you're going to live forever. Nothing happens. I mean, I could tell you, I could write a whole book on the people that have come into my office where we have a motorcycle accident, brain injuries. You got a young wife at home with 3 minor children, and you talk about turning your world upside down.
Yeah,
and then
absolutely.
The wife can't get anything done because they didn't have a power of attorney.
Right.
You got medical bills, everybody's screaming at her to pay, and what are we going to do about this? And it's pretty gruesome and nerve-wracking.
Yeah, and not only are you dealing with the trauma of the event or whatever's happened, then you've got to deal with all these legal issues.
That's right. And now when I talk about power of attorney, I won't get into this, but there are 2 of them. There's one for health care and health care only, and then there's one for everything else.
Yes.
Okay, which is the general durable power of attorney. Now, there are very important documents to have because here's what happens if you don't have one.
Okay.
Which, the caller sort of alluded to the fact that you run into some issues. First of all, if you don't have one, it's going to be hard to get anything done. But it's worse than that. If you don't have one, how do you get one? Because if the person is incapacitated, now they have lost the power to give one. Because to give a power of attorney and sign a power of attorney document where I say I give my son the power that might be my attorney in fact to act for me, you have to be of sound mind and disposing memory. So if you become incapacitated, okay, let's use dementia or just going into a coma. Let's just say you get hit by a bus and you go into a coma, right?
Yeah, okay.
You're definitely incapacitated, right?
Yeah.
You can't make decisions. If you don't have one, you can't give one. You haven't got the authority to do it because you're not of sound mind, right?
Right. You
So
don't have the ability.
How do you get past this? You don't have it. You can't make decisions. The person is the only one that can give it to you is that person,
Right.
And they're incapacitated and can't do it. Well, the only remedy now at law is a conservatorship because you got to go to court. Now, if the person's incapacitated, the only person that can give an involuntary power of attorney. So when you hear the word conservatorship, a lot of people hear that word. Think of it in terms of a court-ordered power of attorney.
Yes.
And the only person that can give a power of attorney involuntarily for somebody is the court.
Yeah.
So you got to go to court and get a conservatorship. It's a very expensive process, and it does not happen quickly. Yeah, it takes several months to get through.
Wow.
And so
Wow.
all this time, you don't have an appointed conservator. I mean, I did one once for TennCare purposes, and I think that one of our circuit court judges kind of bent over backwards and kind of heard it in another county when he was sitting somewhere else. I think it was a Murray County case, and they let me. We heard it in Giles County or Lawrence County. The guardian ad litem that gets appointed in the case. He made his schedule work for me. You know, I told him we were really under a time crunch. Can you do your thing as soon as possible? And he was very accommodating and did. So I think it took us about 30 days, fastest one I ever did. But it was a lot of effort to get that done in 30 days. Typically, you're talking 3-4 months before you finally get to the order of conservatorship.
It's amazing.
And now, once you get the order of conservatorship, the court empowers the conservator, whoever the person is.
Yeah.
And now they have all these powers. It's kind of like a power of attorney.
Yeah.
And they have it, but it's court ordered now instead of just the individual getting it. It can get very expensive. That's a very expensive process. Where if you just do a power of attorney form now, the cost is de minimis. I mean, you know, I think if people come into my office and say, you know, hey, we would like power of attorney.
Yeah.
And there's a power of attorney for healthcare, durable power of attorney, and there's one or two other documents that go with that.
Right.
I mean, I think the cost is about $250. Okay. If you have to go to conservatorship, I tell people right off the bat, it's going to be every bit of $5,000 and probably more like $7,000 because there's attorney involved that has to file the petition. Once you file the petition, the court will appoint somebody called a guardian ad litem, which is another attorney, who does his own independent analysis.
Yeah.
In other words, and this is why. When you go to court and say, you know, Aunt Gertrude needs a guardianship, and I mean a conservatorship, and I need to be. We don't call it guardianship here in Tennessee. We call it conservatorship. If we need a conservator, and I'm throwing my hat in the ring to be the conservator. Well, the court just doesn't take your word for it. They don't know if Aunt Gertrude really needs it or not.
Right.
Because there's a lot of cases where when the guardian ad litem or somebody looks into it, Aunt Gertrude's like, no, I'm fine. I make my own decisions. I don't want somebody doing it for me. And they are.
Right.
Somebody just wants to
They just want to take over.
They just want to take over. So the court has these check and balance system, and they appoint a guardian ad litem, which is an independent party, that will go talk to the ward or the presumed ward.
Right.
We'll go look at the medical records for that person. We'll talk to the people that are saying they want the job. You know, they'll talk to other people in the family that are in a class of people that could also be appointed.
Yeah.
You know, to see if they object to that person. Stuff. So there's a lot that gets done, and then the guardian will issue his own independent report to the court.
Yeah.
Now, let's say it really is kind of a slam dunk, meaning the guy is in a coma, right? Like we talked about.
Right.
So then the guardian ad litem will say, you know, I agree with the petition. This person definitely needs a conservatorship because they're incapacitated. And I've interviewed the person, like the wife, or
Yes.
and they seem to be the proper person for it. And I've also talked to their family members. Nobody is in objection to the wife being appointed. And so that informs the court, you know, that there's no shenanigans going on,
Right.
that sort of thing. That's why and there's a little more to it, but eventually we get to the point where we show up in court and the court reviews all that, and the court will now come out with the order of conservatorship, or what we call letters of conservatorship, and give the power to that individual. And then and only then can they now act for that person. But it's typically 2-3 months later.
Wow.
And about $5,000 to $7,000 later.
Well, you ran across something there a minute ago that made me want to ask a question. You mentioned the medical power of attorney and the durable.
Right.
Now, if you have a durable, and that's all you have, do you really need the medical?
Yes, because the durable doesn't let you make medical decisions.
That's what I was going to ask.
Yeah,
I mean, if you have a durable power of attorney that you're supposed to be able to, I'm just asking as a layman. My thought process is when you have that, then you've got all authority. But not when it comes to medical decisions.
You have all authority over everything but medical.
Really?
And now the medical power of attorney lies in the Tennessee Advanced Care Directive.
Okay.
It deals with the quality of life and the end-of-life decisions.
Okay.
And you have to have that to make those decisions.
Interesting.
It's got its own separate statute for the durable power of attorney for health care.
Ah, okay. So you need both of those.
Yeah.
both
And you can
of
do
those.
something called a living will, which gives more detailed thing of instructions of what you want done. But
I think we've been through that personally.
Yeah.
We've got that in place, but I'd kind of forgotten about the fact that there's two different things. That's interesting.
Yeah. And, I mean, it's that way pretty much in most states. I can't speak for all of them, but I know A lot of times we'll have clients, our trust clients. We do those power of attorneys as part of a trust plan because a part of a good trust plan, you deal with the things that don't survive death. And while we're on power of attorney, which is a common mistake that people make, it does not survive death. So if somebody passes away a week after they pass away, you're saying, well, I'm going to write a few checks because I'm their power of attorney. The bank shouldn't and probably wouldn't honor those. Now, sometimes in small towns you kind of get away with that, but technically that authority goes away at death. And it's an incapacity planning. It's an authority you have for somebody who's alive but can't make their own decisions.
Right.
And so at death, you're usually empowered some other way, either as the successor trustee of the trust or the executor of the will, because now you're not making those kind of decisions. Now, after death, you're dealing with property distribution.
Yeah.
The decisions is kind of over with. So they are very important documents. They're one of my pet peeves. I talk about them a lot because I see a lot of them, and a lot of them are not written very well. They're short. They try to shortcut things because, while we're on the topic.
Okay.
Because it's a good one. And power of attorney, we are a general durable power of attorney state act.
Okay.
Or act state. And it's a uniform power of attorney act. And so when you look at the powers we have in the code, they're in two categories. There's the general powers, and then there's powers called enhanced powers. Okay. Now, the difference between the two is the general powers are the general ones, like buy, sell, sue, be sued, invest, write checks, do on and on. Then you have these enhanced powers, and the difference between the two is if you say in your power of attorney something like, I incorporate all the powers in the code by reference. Okay. The only thing that transfers when you say that are the general powers.
Okay.
The enhanced powers, they're enhanced because they are non-delegable rights, and the only way to pass them in a power of attorney is to have that power express in the instrument. So if you want the enhanced powers, you have to actually list them all in the document.
Okay.
To get them. Otherwise, because it's confusing because a lot of times you'll read a power of attorney and it says my agent can do anything and everything I can do. And when you think about it, it's like, well, that sounds all inclusive.
Yes.
It is not. It does not bring in the enhanced powers. Now, some of the enhanced powers we need, like dealing with another person's trust. If we're doing a trust plan and I'm writing powers of attorney, I'm surely going to put in there that their agent can deal with their trust, right? But the only way for me to make sure they have that power is to put it directly in there. And there's several of them like that. Tax returns. When you file a tax return for somebody else, the Internal Revenue Service has its own power of attorney form. I forget. I think it's 8309. And they will honor a power of attorney that has that, but if it has that general language in it.
Interesting.
And so, it's not when you have a one-page power of attorney that says, all the powers in the code are included by reference. You get all the general powers, which are a lot, but you don't get the enhanced powers. When we were doing estate planning with trust plans and stuff like that, we need quite a few of those enhanced powers. So I always take the position, I put all the powers expressed in the document. It gets to be kind of long. It's 18 pages, 17, 18 pages. Now, I think it needs to be. I've seen that incorporation by reference fail. You get somebody up at Vanderbilt, okay?
Yes.
Something's going on up there where they have like an army of attorneys somewhere that looks this stuff over. That incorporate by reference will fail, and I've seen it fail. So I make all the powers express in the actual document because I take the position it's better to have a power and never need it than to need it and can't get it or have to go to court to get it, because that's the remedy you're talking about. And when you go to court to get something, I don't mean this the way it sounds, but it never happens quickly.
No.
There's a procedure. There's a check and balance system, and it has to be done. Other people get involved. That means their schedules get involved. That means, it just doesn't happen overnight. It's not as quick as saying going to the court and getting the power and walking out in an hour. It just doesn't work. And so if we can avoid that and just put the power in there. I've had people say, well, I don't think that would ever apply. And my response is, well, if it's never going to apply, then it really doesn't hurt to be there.
Yeah.
Because I don't know how many times I can tell you somebody said, I want that taken out, that's never going to apply.
Yeah.
And then later on something comes up and it does apply.
Interesting.
I had a gal tell me one time that, we put some language in trusts that are like after born and adopted children. I don't know, she was in her 60s or something. She said, take that out. I'm not going to have any children. And I said, I understand that, but, it doesn't hurt anything to be in there. She said, well, I just don't want it in. I tried to talk her into it. She wouldn't do it, so we took it out. About 3 years later, she called me. Guess what happened? They adopted. And we had a hole in our plan because of that. Now, I'm not one to say I told you so, but I mean, we had to fix it.
We were talking about that this morning. People hate to hear "I told you so."
Well, I'm sorry, but you know what I mean.
Yeah.
So if it's there and you think, well, that almost looks meaningless to me.
Yeah.
Well, it's a waste of a little paper and a little ink. My advice is leave it there because, when you talk to me on my side of the table, it's always what if.
Yeah, I was going to say you're in the what if business.
It is, and you'd be. I mean, I can what if stuff to death, and I've seen those things happen.
Yeah.
The thing I'm talking about are things you never see coming. They
Right.
just are there.
Yeah.
And it's like now we got to deal with it, and you'd be surprised. It happens to everybody.
A lot of us don't even know what the what ifs are going to be.
That's exactly right. And yeah, I agree entirely. And that's what some of it
And
can't.
you don't know. You don't know what the what ifs are going to be.
I mean, we often say in the office, things come up, and we say, "Man, you just cannot make this stuff up." I mean, nobody saw that coming. But
Yeah.
so it's not. Don't argue with me if you do a power of attorney and it has a lot of powers in there that because they could be needed, and if they're not needed, then it's just then it's just not needed. It's no harm done. But if you need it, it's take an act of Congress to get it in there half the time. So. That's a real pet peeve of mine because I have seen these power of attorneys fail. Because a lot of times I'll get people that, especially in long-term care planning, I get people want to qualify for TennCare, and their son or somebody's acting for them. They have a power of attorney. The ward is already in too far dementia, already incapacitated for making decisions. So I have to live with the one they have. Whoever did it, whatever it is, we have to live with that.
I've seen a lot of examples of the what if I need it.
Yeah.
And it works almost the opposite of what we're talking about. It's like I deal with the states sometimes, and you'll have a guy that's got a barn full of things that he's kept that his wife has probably said, why do you want to keep that? You don't throw that away. What if I need it one day?
Yeah.
And there it is.
Yeah.
The day comes.
That's right. I mean, or it may never come.
It may never come, but if it did, we've got it.
Yeah, that's right. I mean, I'm kind of a pack rat like that.
Yeah.
Especially stuff I'm working on. I'm thinking, no. But here's what happens to me. I'll have something, I don't know, electronic part or something.
Yeah.
And I say, this is perfectly good. I'm going to keep it.
Yep.
And then maybe I need it, and I'll need it 10 years later. I'll pull it out and say, I got one of these things. But this is 10 years old, so I'm just going to go buy a new one. Yeah. So it's kind of keeping it for 10 years for no reason.
Yeah, I have a lot of those things that I just can't throw it away. I just might need that one of these days, and it may sit there for years. Oh, yeah. May never be used, but just in case.
Yeah. So the power of attorney is a very important document.
Yes.
We do have to have them here in Tennessee. It can be a real nightmare if you don't have one. I mean, especially if you're at a young age and you don't have one, and something happens.
Yeah.
Especially if you're young and married, and have minor children that you're dealing with. Now, when we do a guardianship, like if somebody, we appoint guardians if something happens to mom and dad, okay?
Right.
And you say, well, okay, we want to name Ann Gertrude as our guardian. Okay, that's great, but that's not her authority. But in that guardianship documentation where we nominate her, we're going to also put her as power of attorney there's a power of attorney for a minor child.
Right.
And healthcare power of attorney for a minor child. So we'd sign all those documents too, which is the same thing you would get, if you were doing a trust plan, but we're setting it up for the minor child because now that person that's the guardian is going to be making financial decisions as well as medical decisions for a minor child. Now, if you are the parent, you don't need all this to do that for a child. They're the child, you're the parent. You can make these because of that. Now, there are some exceptions to that, but it's kind of in the weeds, and I'm not going to get into it. But,
yeah.
Like if there was an inheritance coming down the pike and it came to the child and he inherited like some land, some real estate.
Right.
And he was only 10 years old. Minors have to have a financial or a property guardian for stuff like that. But like I said, that's a little in the weeds. I won't get into that. But for the most part, you have minor children, right? I mean, so you just make decisions for them.
Sure.
And everybody you deal with honors those decisions, right?
Right.
And that's part of being the parent-child relationship. But once that child turns 18 in Tennessee, whether you think he's an adult at 18 or not, the law does. Yeah. I certainly don't think they're
right,
or most. But now he's responsible for himself, and we see this a lot with special needs children. You're taking care of them, but when they turn 18, you have to go get a conservatorship for that special needs adult child.
Interesting.
If they need somebody, if their disability is at the point where they need somebody to be a conservator, so. I'm a real power of attorney kind of guy, I think everybody needs those. Don't blow those off, because you can hear horror stories. It sounds like the caller may have been involved in some.
So once you reach legal age, 18 in the state of Tennessee, I guess,
Yep.
Then you should really consider having a power of attorney.
I think so. Anything
Interesting.
can happen.
And
No.
we don't think of that. I mean, most of us don't think that that's something that even come into play
True.
at that age.
And here's the thought process. Well, I'm 18 or 19. I really don't own much of anything. I don't have an estate. I got a job maybe, but and so what do I need that for? And I agree. You need it. It's less that you need it for.
Right.
But if something happens, you become incapacitated. It's going to make things very difficult for your
somebody.
family. Whoever's taking care of you is going to go through a lot of headache getting the power to make decisions. Because once you become incapacitated, now there's a whole bunch of decisions need to be made that didn't have to be made when you weren't incapacitated.
Right.
You've introduced a whole new level of medical stuff.
Interesting.
And we talk about the medical one versus financial. They overlap a little bit, or get fuzzy, because healthcare are healthcare decisions. But if you have to pay the hospital or something, that's not a healthcare decision. That's the general durable one. So
Right.
they kind of get fuzzy between the two. They overlap, because paying them or dealing with them financially, or dealing with them with admittance, signing the admittance form. and stuff
Yeah.
like that, that's not the healthcare we're talking about. The healthcare are the decisions on health.
Yes.
Yeah, it's the treatment, the medication, stuff
Yes.
like that, the pulling the plug stuff, all that.
Very interesting.
Yeah.
A good something to consider there. That's a good deal. Good
I
deal.
mean, there's a lot behind the power of attorney, but you definitely need them. And I don't say that because because you can come to me and we do them. I'm just saying I've seen a lot of, I do conservatorships, and there seems to be always one going on in the office at any given time.
Yeah.
And a lot of time it's for somebody young that got hurt.
Yeah.
Recently we had one where, just like I said, had a motorcycle accident, brain injury.
Wow.
And the person wasn't going to come back and be the same.
Yeah.
And had a wife, and I'm talking about somebody who's in their 20s, mid to late 20s, and had 3 minor children. And
Wow.
the wife was just frazzled because she couldn't do anything. Creditors are hounding her. You know what I mean, it was a nightmare for her. So we did conservatorship. We got it through as fast as we could, but we got it. Now she can make decisions. But again, like you said, on top of her life being completely inverted,
Yeah.
because got a husband now that's got brain injury and he doesn't work his job anymore.
Right.
Where's the income going to? I mean, just you can imagine.
It's a
You can
terrible,
imagine.
terrible circumstance.
On top of that, she's got to deal with all this. So
Well, that's one of the reasons why that people should see you or someone like you to do this kind of planning, to take care of the what ifs that come in our lives, and to assure that what your plans and wishes are fulfilled once the inevitable does take place.
right.
That's what we've talked about so many times here. So it's wills, trust, estate planning, bulletproof estate planning. That's what you're about.
Yep. And on some of these documents, not just the power of attorney, but some of these other documents, you can name people you want to be your fiduciaries, right? But you can also name people that you want to make sure are excluded from being your fiduciary.
Yeah.
We did a trust, and where we were leaving property in trust to a child who was a minor, and we wanted the successor trustee to appoint a trustee over this trust, whenever the inheritance passed.
Yeah.
But they specifically wanted to exclude somebody. So we put that language in there and said the trustee has the authority, can be the trustee for the child or can appoint a trustee for the child. But of all the people the trustee can appoint, they shall not have the authority to appoint Jane Doe.
Yes.
And that excludes that person. Now they can't. Now they're bound by the trust rules not to be able to put that person in power for that, because it was somebody they were worried that if they're in charge of the child's inheritance, the child's not going to end up with an inheritance.
Yeah.
Right?
Yeah.
So you can actually exclude individuals if you need to, especially in guardianship. A lot of people say, well, I don't mind if this person takes care of my kids if something happens to me or this person, but man, I absolutely positively do not want this person taking care of my children.
Right.
And that person may throw their hat in the ring, especially if you have a large insurance policy or something on your life. If you're a 30-year-old father with children, it's only prudent you have a $500,000 life insurance policy. So if something happens to you, something can stand in your shoes, at least financially, right?
Right.
And when you get a policy like that, and you need guardians for your children, it tends to attract people.
Right.
Hell, I'll take care of those kids. There's this $500,000 life insurance policy that goes with it. Now they don't understand because that's a fiduciary duty and that's for the raising of the children. But You know how people are.
Yeah.
Money brings out the worst in people. And so this person may throw their hat in the ring, and so we want to put in a specific exclusion. Say that it can't be this person. And that will carry. That exclusion will prevent that from happening. And all because it is the person's intentions, their wishes, what they wanted. What you want when you write in the trust, the legislature, if you read you hear people talk about TCA, stands for Tennessee Code Annotated.
Okay, yes.
Well, there's the code, but then after the code, there's what they call the annotations, which are the discussions of the legislature and on why they did what they did in that code, what problem it solved, where it made something better or worse or wider or narrower, and stuff like that. There's a lot of neat information in the annotations. And in the annotations for the trust code, there's language where they say, the trustor, which is the maker of a trust, the trustor's intent is paramount. And I know no other place in the law where it makes that kind of statement. And basically it says the trustor's intent is paramount, and absent any compelling evidence will not disturb it. So, you've heard me before. This is what I call writing the rule book.
Yes.
The legislature has given you a green light. When you write a trust, write the rule book.
Yeah.
And it doesn't matter how ridiculous what you put in. I'm not saying put something ridiculous in there. I'm making a point.
Yeah.
You could say, okay, here's my trust, but during the trust administration, I want orange juice brought in at 9:15 every morning and given to, something stupid, and it'll be enforced because you're writing the rule book. Absent an illegal purpose, they will honor whatever you put there. And I every now and then I cite examples that I see in court cases about, there was the one I probably talked about recently where the mom leaves it to 2 kids but says if the son's married to the person he's married to when I wrote this, then he doesn't get it.
I remember you telling me that.
And so the court upheld that.
Yeah.
Because the first thing the kid did was still married to her, in the court and said, this is a big infringement on my right to own property. And the court said, well, wait a minute now. This is a trustor's money. And the trustor's intent is paramount, right? This is what they said in the law. And therefore, if we can determine her intent, that's what we're going to enforce. And her intent is, if you're still married to whoever you're married to at the time of writing, you don't get it. And unfortunately for you, you are.
Yeah.
So you don't get it. We're enforcing that. And
Fortunately or unfortunately.
that's a beautiful thing. I mean, if you can, nowhere in the law can I think of another place where you write the rule book and the courts will enforce it.
Oh, wow.
I mean, it's pretty cool when you think about it. So, and most people don't put ridiculous stuff in their trust, but they do. They do put terms and conditions a lot.
Yeah, well, the whole point is that you get to decide exactly
That's
what
right.
you want to make happen.
And if you want to decide exactly what you want to make happen, it has to be memorialized in an enforceable instrument. Means you got to do something like get it down in writing into a trust. They don't have that language for wills. I mean, the intent in the will is not necessarily paramount. That can be challenged. But you got to put it down. You got to memorialize it. Okay.
Yeah.
Once it's in the trust, then you've.
That's an interesting thing to talk about right there. Is that wills can be challenged, and sometimes even overruled.
And the probate court is required to entertain all challenges.
But the trust cannot be.
Well, let me put it this way. I'm not going to say it cannot be challenged, but there's something called a no contest clause.
Yeah.
It's called an interim clause in Latin. It means it's basically a clause that says if you challenge, the deceased is saying, if you challenge what I'm leaving you, then you don't get anything.
Interesting.
Now, that is completely unenforceable in probate. It's kind of a waste of paper and a waste of ink to put it in a will, because if somebody has a challenge, probate court will allow it. Okay. Now, however, another thing the legislature said about trust is we will give it 100% full force and authority in a trust. It is 100% enforceable in a trust, and I've seen some cases like that. So if you're going to, so I can't say can I say you can't challenge a trust? So if you have a trust, I can't promise you, Jeff, your kids won't challenge it.
Yeah.
But what I can probably promise you is if they do try to challenge it, the next best thing is that it'd be impossible for them to be successful. But they can, if they'll find an attorney that'll take
their money,
take the money and do the job, they can challenge it. But
Yeah.
the trick is, will they be able to carry their burden? And even if they can, it'll trigger the no contest clause, and they'll take as if they predecease. So it's a powerful incentive, and that's what the whole thing is designed to be. The deceased is not here to argue their intent.
Yeah.
But they're saying, listen, here's what you get. It's my stuff. I'm leaving it to you. If you don't like what you're getting, then you want to challenge it, then you forfeit it. So just take what's coming to you and be happy about it.
Yeah.
And it's kind of what the incentive is. So it's a big incentive. If somebody wants to challenge the trust and they go to an attorney that is reputable, we'll tell them, look, you're taking a tremendous risk.
Yeah.
If you're getting a third and you think you deserve a half, just by challenging it, you're going to end up with nothing.
Yeah.
Do you want to do that? I mean, it's a deterrent.
Yeah.
I said incentive. I mean, it's incentive not to challenge, but it's a deterrent to challenge.
Sure.
I mean,
sure.
the stakes are high if you want to challenge it. So, I mean, you may not like it. You may feel disgruntled. You may feel like you deserve more. But, when you get an inheritance, it's a windfall. There's no entitlement to an inheritance.
Yeah.
There's no right to it. Actually, I actually saw a case one time where this one just makes me laugh. It came out of California, which maybe explains it, but makes me laugh. And I was on the fringes involved with it. Okay, guy had a living trust, and he went in and took a bunch of family members out, extended family members, just took them out. Now, I'm not sure how they found out they took him out, but they filed an action in court and sued him. Said, "Hey, we were in his living trust, and he took us out."
Oh wow! Oh wow!
The opinion of the court was very short, and it said, "Look, basically what it said in Reader's Digest version. So look, when somebody writes a living trust, it leaves the property at death." Okay, this guy was still alive, right?
Yeah.
He changed his trust.
Yeah.
And they said, in a living trust, you are a beneficiary at the whim of the trustor.
Yeah.
They can make you a beneficiary. They can take you out with a stroke of a pen.
Yeah.
And they can do whatever they want. So, case dismissed. Basically what they said was, if you have a complaint, it's not ripe.
Yeah.
It's ripe at death. And you say, oh, I should have got more in this thing. Now, but again, if you're going to come in and say that, then it's a matter of proof. I mean, just saying it doesn't get you there. That doesn't make it so. Anything in court is a matter of proof. They'll hear it, but you got to prove that. Okay, Jeff has 3 children. He left a third to each, and the child that's disgruntled has to prove why he should get a third, more than a third. And
Yeah.
I mean, that's a tough road to hoe.
That is a tough.
I don't see what the proof they're going to put on. I can't even come up with a silly example. To be honest
Right.
with you.
Exactly.
Absent maybe a videotape of somebody holding a gun to your head saying, "I want you to not give that child anything more than a third,"
Yeah.
and you're in duress because they're holding a gun. But it's a ridiculous example.
Sure.
So it's very difficult to be successful if your complaint is what you're getting.
Yeah.
Now, if you're getting screwed over by the trustee, you can take that to court and it doesn't trigger the interim clause. Not all challenges triggers. Let's say this. Let's say your 3 kids each get a third.
Yes.
And one of them is your trustee, your successor trustee.
Yeah.
And they're mad at her brother, okay? And they say, you know what? My brother hadn't called mom and dad in the last 10 years, hadn't even sent him a Christmas card. I don't think he deserves that third. I'm only going to give him 10%. Well, that person can sue and say, wait a minute, I'm not challenging what I get. I'm happy with my third, but I'm not getting my third. The successor trustee is breaching their fiduciary duty, substituting their judgment for the deceased and shortchanging me. Now, that does not trigger the no contest clause because you're not arguing about what you get. You're arguing that the successor trustee is dropping the ball on their duty.
Yes.
So those are challenges we kind of welcome because they're designed for the intention to be accomplished.
Yes.
We do not want a successor trustee that, like I just said, substitutes their judgment for yours. Says, you know what? I'm pretty sure Aunt Gertrude didn't want to do that, so I'm going to make sure. I'm just going to change. I'm just going to do something different.
Yeah. So
we don't want that.
The successor trustee is responsible for seeing that the trust is honored.
And I've told successor trustees who disagreed with what they had to do, I'd say, you know what? Bite your lip, write the check, hate every minute of it, but write it. Because if you don't, that person's going to sue you.
Yeah.
And don't come to me to defend you because I can't win that one. I can't. You have a fiduciary duty to do it. Mom says in this trust. The fact that you like it or agree with it has nothing to do with it. Yeah. You have a fiduciary duty to do it. So if you're not going to do it, then resign and we'll let the court reappoint somebody else or something like that.
Yeah.
But you get that. So we want to pick people that'll do what we want to do.
Sure.
But that, like my point was, you can there's certain challenges that don't trigger that really harsh clause. But if you trigger it by not agreeing with what you get and want more, your day is going to get worse.
Yeah. Well, yeah.
And then there's no going back from it. If you trigger it and you get nothing, there's no saying, okay, I'm going to withdraw the petition and not file. I've seen trusts that actually have that escape clause and say if you withdraw it within 30 or 60 days,
Right.
then you're reinstated. But you have to say that to happen. So.
Well, you've used the slogan, I guess, bulletproof estate planning, and of course we know in slang language what we mean by that. But what you're talking about is setting things in stone.
We're trying to make it so that what the person wants is how it ends up.
Yeah, you set it up in stone, and it's made where it really can't be challenged or can't be successfully challenged.
And there's always the what ifs, and some things I guess can happen that that maybe weren't covered, but
Yeah.
you learn, sometimes you live by doing, and but we've seen a lot. So
And then there's the aspect too that we've talked about many times before about how doing these things now and preparing for the future and things that may happen in the future also saves your estate for those who you want to save it for.
Absolutely. And it minimizes any kind of cost that gets lost from the estate that doesn't go to those heirs because it gets consumed in the cost. That's right. The whole idea of estate planning, the word planning kind of means do something ahead of time.
Yeah.
So
We're
winding down.
We are. You might want to just review right quick the seminar coming up again in a couple of weeks.
It's 2 weeks from tomorrow, I guess, November the 2nd. I call it Will's Trust in the Nursing Home, and that's kind of what we'll talk about. And it's at 10 o'clock in the morning. It's up in Franklin, Tennessee. It's at a place called Suite 501. The physical address is 416 Mary Lindsay Polk Drive, Franklin, Tennessee. Nice little venue. If you want to come to that, just call my office at 931-363-7222 and get on the RSVP list. If you can't make up your mind to the last minute, just pop in. We'll handle walk-ins. We'll have some light refreshments and that, but it starts at 10 o'clock and it starts really close, almost right at 10. And it'll be nonstop information for about an hour and 15 minutes. And then if you have questions, bring them with. And if you have any questions during the presentation, write them down. And at the end, we do an extensive Q&A and ask you, fire away, challenge me. Ask me tough questions. I welcome them, and I will answer each and every one of them. So, otherwise, just call my office, like I said, at Pierchoski State Law, 363-7222, or go to my website, estateplanstand.com. You can see my calendar, send me a question by email, something like that. And don't forget, 3 weeks from tonight, opening night for Grease at the Star Theater in Pulaski, Tennessee. So
I'm looking forward to that.
Golden Grease.
Golden Grease right there. I think that'll be a lot of fun. The holiday season coming up, and those are the kind of things that we like to see and do in the community like that. And it's kind of cool that you're involved in the local community like that.
It's
community
fun.
Theater.
It's fun.
Right there on the public square in downtown Pulaski, Tennessee. That's where your office is located, and not hard to find at all. Pierchoski Estate Law. That phone number again, 363-7222. Stan, thanks for being with me again this morning.
Always a pleasure. We will see you next Friday for the next episode of Bulletproof Estate Plan.
That's right. Thank you, man.
From joking on stage to campaigning on TV in the morning.